So this is actually the most common type of ownership because if your deed does not specify right of survivorship and you own property with someone you are not married to, then this is how you're going to own property. Hey everybody, I am Tiffany Weber and I am a real estate attorney in North Carolina. And today we're going to talk about 3 different ways that you can own property with another individual. So the first one is called tenancy by the entireties. And this is a form of ownership that is only available to married individuals. So if spouses own property together and the deed says to this person and spouse, their spouse's name, then that defaults to tenants by the entireties ownership. So that means that you have protection from individual creditors. What I mean by that is if you own property in this way, tenants by the entireties, but then one of the spouses gets a judgment against them individually, then that protects the property that's owned jointly as tenants by the entirety from being seized or forced to be sold to pay off that judgment. Now, if you get a judgment against both of you, then yes, it could affect your tenants by the entireties property. And of course, there are special exceptions to basically every rule, but in general, tenants by the entireties property is protected from individual creditors. This also means that when one spouse dies, the other spouse will own the property completely, and this happens automatically at the spouse's death. The next way to own property with an individual is as joint tenants with the right of survivorship. So this means that if one of the individuals passes away, then the survivor of the two of them will own the property completely. So it's similar to in tenants by the entireties, where if someone passes away, the other owner will own the property completely, but there is no creditor protection. So if one of those owners gets a judgment against them, then the property will be subject to levy to pay off those judgments. Or in other words, the judgment will attach to the real property. And the percentage of ownership between these joint tenants, if not specified in the deed as something other than equal shares, then the law presumes that you own the property equally. And the final way to own property with an individual in North Carolina is as tenants in common. So this is actually the most common type of ownership because if your deed does not specify right of survivorship and you own property with someone you are not married to, then this is how you're going to own property. So if the other owner, the other person that you own the property with, passes away, then their share does not automatically go to you unless you were named as the heir or the beneficiary in their will, or you are somehow their heir under the laws of intestacy if they didn't have a will. So in tenants in common, if you pass away, your share goes to your heirs. It does not go to the other owner of the property. And again, you can specify different percentages of ownership with tenants in common. So those are 3 different ways that you can own property with another individual in North Carolina. So hopefully that was helpful to explain that concept to you. If you like watching videos about real estate law, we make a lot of videos just like this one. So go check out my channel and I'll see you in the next video.